of Appeals, First Appellate District of Ohio, with the Honorable Jennifer Kingsley presiding, is now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have 3 cases set to be heard this morning. When I call your case, please stand, state your name, the party you represent, and your readiness to proceed. The first case this morning is case number C-24-0322, Wood versus the Kroger Company.
Good morning, Your Honor. Anita Washington, Helen Natalie Wood, and we are ready to proceed.
David Connors on behalf of defendant appellate the Kirk Company, and Kirk Company is ready to proceed.
All right, thank you. The second case is case number C-24-0273, State of Ohio versus Kojuan Curry.
Good morning, Stephanie Kessler for K1 Curry, and I am ready to proceed.
Your Honor, excuse me, John Hill on behalf of Plaintiff Police, State of Ohio, ready to proceed.
Thank you. And the last case is C-24-0266, State of Ohio versus Brian Harris.
David Hoffman for Mr. Harris, ready to proceed, Your Honor.
Again, Your Honor, John Hill, also on behalf of Plaintiff Appellate, State of Ohio, ready to proceed.
All right, thank you so much. We will move forward with case number C-24-0322, and the attorneys can come forward. Ms. Washington, you may come to the podium. Would you like to reserve any time for rebuttal?
I would, Your Honors, 3 minutes.
All right, give me just one moment to set up my timer here. And you may proceed when you're ready.
Good morning, Your Honors. Again, I'm Anita Washington. I represent Natalie Woods, the plaintiff appellant in this court. May it please the court. This case is a premise liability case, and there are 3 assignment of errors today that I would like to discuss. First, that there was no findings of a natural accumulation of ice, that there was no finding of knowledge of ice, and that there was no finding of knowledge of notice of a defect in the canopy. The overarching question in this case is the natural accumulation of ice, and Mother Nature controls that question. When the snow...
On that point, Ms. Washington,
Ma'am?
do we know when it would have rained or snowed prior to the incident to Ms. Wood?
Yes, Your Honor. In the week prior to the incident, it had snowed and rained.
And how do we know that in this record?
Your Honor, I'm not sure if it was in the record, but in the MSJ and in the discovery, we did present record of the weather forecast for that week.
What was the source of that information?
I believe it was just the weather.com for that particular, for the Cincinnati area for that week. And there was snow that had snowed in the 2 days prior, and the weather had become warmer, and the snow began to melt. When it began to melt, it melted through a hole in the canopy. When it melted through that canopy, in the weather as it does as nighttime falls and the sun goes away, it began to refreeze in front of pump 11. Now, that is not supposition. That is known to us because an agent of the appellee put that information in an affidavit, and that is the information that she made known to the appellee. She called into she worked inside of the booth. If you're familiar with the setup of Kroger's, under the canopy, there is a booth where a clerk works to take money for cash payment of the fuel station or for food items outside of the fueling station. And she worked in that booth. Walking into that booth, she slipped. She didn't fall, but she slipped on ice in front of fuel station 11.
Did she say in the affidavit, like, when that happened? Like, how soon before?
She
your
did
client?
not. She said
Okay.
prior to the incident.
So
She
we don't have a
didn't-
timeline.
She did not say the timeline,
Do
Your
we
Honor.
know if it was, like, close in time?
So I'm going to be honest with you, Your Honor, I did not take that affidavit. That was taken by an attorney prior to me becoming part
Okay.
of this case.
All right.
So I do not know the actual timeline, but she said prior to this incident.
And Ms. Hale was not deposed, right? So
She was not.
the sole source of what she has to say, at least right now, about this incident is her affidavit, right?
To an extent. When Ms. Wood fell, as can be seen on the video, that is part of the record, Ms. Hale runs out and asks Ms. Wood, is she okay? And she says, I told them someone was going to fall. So, but again, she doesn't say, I told them on what date and what time.
And where is the video? How is that made part of the
The
record?
video was entered in, it was definitely part of the MSJ, and it was entered as part of this record. Now, how it was entered, it's my understanding that it was entered as a thumb drive as part of this record. I know that the still photos were also entered as part of the record. So, and as part of the transcript, deposition transcript, Ms. Woods does acknowledge that Ms. Hale came out and made this statement.
Well, is Ms. Woods' deposition, her entire deposition, is that a part of the record?
Yes, ma'am.
And where is that in this record?
We entered that with Ms. Woods' deposition transcript and Mr. Woodard, the 30B6 representative for Kroger's, were both entered as part of the record for the appeal.
So we have Mr. Woodward's. We don't have Ms. Woods, and I think part of the confusion here may be that there was a first case that was filed.
Yes, ma'am.
And that record isn't a part of this record. So we don't have Ms. Woods' entire deposition. We have the pieces of it that were attached as exhibits to Kroger's MSJ, but not the entire deposition. Would that have been filed in the first lawsuit?
Yes, ma'am, it was filed in the first lawsuit, but when we asked for the transcript, I thought we sent over the transcript and the depositions for Mr. Woodward and Ms. Wood.
All right, we'll clarify that, but just want to understand from your perspective what is a part of this record.
Okay.
And it's your belief that the entire Wood deposition is a part of this record?
That is my belief, Your Honor. If I am mistaken, then I will speak today on what Your Honors is telling me is actually in the record, and I will stick to just that information today. So then based solely on Ms. Hale's affidavit, in it, and if I will stick, well, just with line 5, Ms. Hale states that prior to the fall, that she called inside and told them there is a hole in the canopy. The significance of that is Ms. Hale was not a passing guest who walked by and made a suggestion in a box, or who fell and said, hey, this had to have come from this box, or it came from this hole. She was someone who spent 8 hours a day working at this facility. So when this hole developed and began leaking water, that was a concern to her. And then when it formed ice in front of pump 11, the very same pump where Ms. Wood fell, it was of concern to her, and developed ice as she called inside and made a warning of said ice.
So is it your
yes.
position that the ice on the ground came from a natural source, being the sky, and that the hole in the canopy had nothing to do with it? And therefore, this isn't a construction defect situation. It's not an unnatural situation that would require some sort of special expert testimony.
Your Honor, never once in our pleadings from the complaint till today did we ever call this a construction defect. We call this a defect. It is a requirement of a premise liability case that the premise be defective, hazardous, flawed. If the premise is in pristine condition, there is no premise liability case. It's just a fall. So it's a requirement of a premise liability case that there's a defect, flaw, hazard in the premise. There is a defect in the canopy, and that's what we've always called it. The appellee took it upon themselves to add the word I believe they added the word construction defect. We did not call it a construction defect one time. They took it upon themselves to call it a construction defect 31 times. That is not our contention.
Because they're arguing that you need to have an expert.
That is correct, and that is the purpose of calling it a construction defect, is to add in the added requirement of an expert. It is beyond the pale to believe that a layperson does not understand what a hole is.
What kind of hole are we discussing? Is it like
It's a hole.
tiny little hole?
It's
or
a hole, Your
gaping
Honor.
hole?
Yes, Your Honor, because we have seen the hole. Pardon me.
Is there a photo of this hole
There is a photo
in
of
the record?
There's there is a there
We
is-
can only look at what's in the record.
there is a photo of the hole, Your Honor, and
Is it in the record?
let me back up and say it this way, Your Honor. We had a photo of the hole.
Okay.
Defense or the appellee asked or filed a motion to strike our expert, stating that jurors were, Ohio jurors understood weather, and that our expert wasn't needed to explain weather, holes, dripping ice, things of that nature. So our expert was pulled.
Okay.
So for then they turned around and said that we didn't explain what a canopy was. So on one hand, they're saying that Ohio jurors are smart enough to understand precipitation, but not smart enough to understand to stand up under a canopy when that precipitation falls.
But what does that have to do with the picture of the hole?
Because he was the one who took the pictures of the hole.
Expert?
Yes, ma'am.
So I'm still confused of why the picture of the hole is not in the record.
Because his whole expert report was pulled, because
Okay.
the expert himself was pulled.
So now we, the appellate court, don't have a photograph of the hole.
They do not have a photograph of the hole, but Your Honor, this is the motion for summary judgment portion, where we have the directed verdict portion of the case, and we were lacking this evidence. That would be this would be the point of time where we could say, we're lacking the picture of the hole, we're lacking evidence or testimony, so you didn't meet your burden of proof. Right now, we have submitted into record statements saying there was a hole by an agent of the appellee.
And that there was a photograph of the hole
Correct.
taken that is going
Correct.
to be used at the trial.
We have submitted into record.
Where is that documented, that there is a photograph that exists and that you will use it?
That's in the transcript of Natalie Wood.
Okay, so whether the Wood deposition is in or out of the record is critical in terms of fleshing out whether that point is in or out of this record.
That is correct, Your Honor. And that is also, it's also important to note that in Natalie Wood's deposition, she also states that she went back to the premises and she visualized the hole for herself. And at that time, it was also dripping water because it was warming up and water was dripping through the hole. So this is testimony that the plaintiff herself will give, firsthand knowledge. Defendant is saying that that doesn't prove that it was dripping that day. It's the same hole in the exact same spot over the exact same pump. So the inference can be drawn, and that inference must be drawn in favor of the plaintiff. If the snow had blown in after it had fallen, then that would be, we wouldn't even be standing here today talking. But it's not as if we're saying, hey, we found a hole, maybe that's where it came from. But prior to the plaintiff even falling, someone had put the appellee on notice that there is a hole, water is coming through it, it's freezing in front of pump 11, and someone's going to fall. Someone
Counsel,
pulled
you
up.
are out of time if
Oh.
you would like to reserve for rebuttal.
Thank you, Your Honor.
Thank you.
May it please the court, Jacob Connors on behalf of defendant appellee, the Kroger Company. This case is fairly straightforward. Plaintiff appellant alleges to have slipped on an alleged patch of ice roughly 2 feet in size in the fuel station parking lot of a Kroger. Plaintiff alleges that the ice formed because of a defect, presumably a construction defect.
Back up for just a second. Now, when you say construction defect, what does that mean exactly? Does it mean when it was constructed? Or does it mean that a hole has formed due to just time and maybe lack of maintenance?
I believe that what plaintiff is alleging is both of those would fall under a construction defect. There was some issue with how it's constructed, either at the time or now. I don't believe that Kroger's alleging that there's no construction defect, so I don't know exactly.
So, all right, let's say for a moment that there's a house and it has a gutter that is hanging off and it's swinging back and forth. Do you need an expert to say that that's a defect?
For the gutter itself? I would, no, and there's case law that says you don't need one. So.
Yeah, okay, I understand that. So if it's obvious, then you don't need an expert, correct?
I don't believe that's necessarily correct. I'd say to show that a construction defect existed and then that construction defect then caused whatever unnatural impediment of water is where the expert is needed.
So if this hole, let's say if a hole, not even this hole, if you were walking under a building or under a canopy and you could look up and you could see a hole and you could see water dripping, what could an expert add to that?
An expert could add that that's not the normal design of the...
They wouldn't know simply because there was a hole in the roof?
Not necessarily. I mean, there would need to be something that would show that there would be a better design out there and available or something like to that extent.
But wouldn't that help the plaintiff? That would help Ms. Wood if you presented an expert to say that there was a better designed roof that would prevent the flow of water.
Yes, that would. I agree with you that that would help. So there's no expert in this case at all, so there's no one to say that it was defective in any manner.
A hole in a roof is not defective?
Not necessarily. I mean, a gutter has a hole essentially going down.
I'm not talking about the gutter, I'm talking about a roof.
Yes.
A hole in a roof is not defective
Not necessarily.
by definition. Can you explain a situation where it wouldn't be defective?
So especially with things that are flat, I mean, I'm not a construction expert, but flat surfaces that sometimes have holes in them that allow water to fall through, so there's not so much snow sitting on top that would cause it to cave in and fall, as would a gas station canopy, along with the fire suppression system and all that stuff. So the main purpose, in my understanding of them, is to protect the gas pumps from natural elements.
So we're not seeing this hole because I believe your adversary conceded that the images that were taken were withdrawn from the record with the expert report. So I think we're conceiving of literally like one piece of metal with a big hole in it. Are there circumstances when the structure might be more complex than that and would require an expert to explain to us or a jury how a hole in some kind of roof would impede the flow of water in some way?
Yes, Your Honor, I believe that would require an expert.
Could you explain a circumstance like that to me? I'm not a construction expert.
So, I mean, for example, in the court in Notman and in Daly, they found that in order to show that any kind of defect in a structure, such as a hole or anything, would require expert testimony to show that that was defective and not either there by design or for another reason. I mean, an expert would be required to show that they looked at specifications, building codes, et cetera, to show that what was designed was defective in any way, shape, or form.
What about the allegation that it had snowed a week before and there was proof that this had happened? Do you concede that that's the factual landscape in this case?
There's nothing in the record to support that, so I wouldn't concede that. I mean, if it had snowed, I would put plaintiff more on notice, but there's nothing in the record to suggest that that's what occurred.
Could we take judicial notice of the weather that week?
That would be up to the court. I mean, I have nothing to support that you couldn't take judicial notice, so I'm not going to make the statement that you could not take judicial notice of the weather.
And what about the status of the full wood deposition? So I noticed that Kroger attached some pages of it to its summary judgment motion, but I don't find the full wood deposition anywhere else in this record. Is that your understanding of the record?
Yes, based on the trial docket that I saw, there's nothing in there other than what was attached to Kroger's motion for summary judgment.
And is it your understanding that the full wood deposition was filed in the first action?
I do not believe it was. So the first action was dismissed after Kroger moved to strike the second report of plaintiff's named expert. So plaintiff's named expert's first report found that the ice was a natural accumulation, and then subsequently tried to change his opinion right before motions were due. So we filed a motion to strike, and I believe plaintiff, knowing that she needed an expert for a defect, dismissed 41A, dismissed the case and refiled.
So was the wood deposition taken in this lawsuit or the first
It
one?
was taken in 2022, which would have been the first lawsuit.
All right, so there's a possibility that it's filed there.
And that is possible, yes, but I do not believe that it was.
All right, do you have a position, and I realize I'm putting you on the spot, but do you have a position as to whether we could consider that deposition since it's in the other record?
I do not, but if the court would like a briefing, Kroger would be happy to brief on the matter.
All right.
But your bottom line argument is, with or without this deposition, this case lives or dies because she didn't have an expert to testify about the whole.
I don't believe that it lives or dies with that. I think that it alone shows that Kroger is entitled to motion for summary judgment, but there's other aspects. I don't believe that anything in the record suggests that Kroger had notice of any sort of defect.
So what about Ms. Hale's affidavit? I mean, she said that, and I'm going to quote here, I warned fuel manager Randy Woodward prior to this incident of a hole in the gas station overhang that allowed water to create a pool on the concrete and freeze by the pump Ms. Wood used. When reporting the condition, I told him that I thought the ice was a hazard and someone could fall. How is that not notice?
I mean, it's not notice of a defect. I mean, she merely states that water can come from the roof and refreeze on the ground. And, I mean, that is not uncommon in anything, and that's not negligence on Kroger's behalf.
But that's, you said that there was no notice. Okay, so if we determine that this hole was a defect, what kind of notice should there have been?
So the hole itself is not a defect. I mean, the affidavit of Randy Woodward establishes that's not a defect. I mean, nothing in Ruth Hale's affidavit even suggests that it is a defect. She merely states that there is a hole, not that it was defective in any manner.
Am I understanding you to be implying that the hole could have always been there then? Is that what you're saying, that the hole was a part of the roof always?
That's not what I'm saying, and nothing in the record suggests that there was a hole always. There would need to be an expert testimony. I would not be qualified to say whether that hole was always there, whether it was designed to be there, and that's where the expert comes in, what would be required, and it's not in this case. There's not an expert.
In other words, I don't want to put words in your mouth, but I want to make sure I understand your point here. the hole could have been a part of the design of the roof, not some kind of later occurring problem with the roof. We just don't know.
Exactly, that is possible. I mean, in the record, nothing shows that it was there prior or part of the design or developed over time. Nothing in the record suggests any of those things.
So are the awnings there to keep precipitation off of the pumps and the customers?
Again, there's nothing in the record that would suggest that. I would also believe that that would be something that would require expert testimony for the purpose of, or the deposition of a 30B5 rep of Kroger who would be able to testify as to why they decided to put gas station or fuel station canopies up. But my understanding is that they're there to protect the pumps themselves as it's combustible material.
Okay, thank you.
Further, just moving on, plaintiff appellant also has argued in briefing that she asked the court to consider the open and obvious nature of the alleged hazard. While the issue is brief, the trial court made no determination with respect to the open and obvious nature of the alleged hazard after determining that the alleged ice was a natural accumulation and that Kroger had no notice of such alleged hazard or of any defect in the fuel station canopy. Should this court determine the issue worthy for review, it is apparent that the spot in question was open and obvious. The alleged danger...
Doesn't the open and obvious question come down to the natural versus unnatural accumulation question? Don't those two fold together?
They can fold together, and the trial court, understanding that the accumulation was natural, chose not to proceed to that. But just because it was natural or unnatural doesn't mean that it couldn't be open and obvious. For example, the court in Leidick v. Lowe's held that...
For example, could it be an unnatural accumulation but then still also be open and obvious?
That is correct, yes. So it could be, I mean, this specific alleged hazard was natural, but theoretically speaking, there could be an unnatural accumulation of ice that would then also be considered open and obvious.
And is it your position that this ice patch was open and obvious?
Yes, regardless. So I believe that it was natural, so the open and obvious analysis was not needed, but it is Kroger's opinion and my opinion that it was open and obvious regardless of natural or unnatural.
And why is this particular ice patch open and obvious?
Because it was observable, so in plaintiff's deposition, she testified to the size of the ice patch, it being 2 feet in size. Also that she was able to clearly observe it.
But that's when she was on the ground, right?
Yes. In Leidick v. Lowe's, the question is whether it is observable, not whether the plaintiff did observe it.
I understand that, but I guess what I'm saying is, I mean, sometimes ice is really hard to see. So is it, I mean, yes, she said that she observed it, but that was after she fell. She could see it when she was on the ground, you know, that far away instead of 5 feet away. So does that matter?
For this situation, I do not believe it matters. So the photographs which were attached to the affidavit of Randy Woodward show how open and obvious the alleged ice patch was. I mean, you can see it from the camera, which is, there's nothing in the record to suggest how many feet away it is, but it...
How do we weigh the fact that another person, just mere seconds before this, walked right across the same patch of ice? I mean, isn't part of the open and obvious doctrine the recognition on the part of the person encountering the hazard that it is in fact a hazard? And the fact that somebody else walked right across it right before would suggest to me that people wouldn't immediately recognize this as a hazard. Can you address that?
Yeah, so there's nothing that would suggest that the person walking right over it, I believe that she did see it, and that's why she took the steps she took to not slip on it, if that's what it was, ice. Regardless, the person walking through also would just open the door for there being other causes of the slip, which was briefed in our motion for summary judgment, being that plaintiff can't show that she didn't slip because of some substance on her shoes or anything else that could have caused her to slip, which plaintiff would have to rule out in order for her to be able to defeat Kroger's motion for summary judgment.
But wouldn't the operative facts that I think you're pointing to be in her deposition?
Yes, but those, yeah, were in her deposition and attached to Kroger's motion for summary judgment.
All right, so you've supplied those transcript pages.
Regarding her alleging that she couldn't rule out that there was another substance on her shoes, yes.
All right.
At what point would that become a jury question, though? I mean, isn't it up to a jury at some point to say, okay, the fall wasn't caused by the ice itself, it was caused because she had something, she might have had something on her shoes?
I do not believe that's a jury question. The case that was cited, Gedra, establishes that once one of those is raised, it's up to the plaintiff to rule out those causes that the defendant would not be liable for.
Okay.
Continuing with the open and obvious argument, this court has held that conditions are open and obvious when the alleged hazard is visible to the naked eye in photographs and when visibility was clear.
And counsel, you have about 30 seconds left.
Okay. Thank you, Your Honor. That case is Hammond v. Lott citing Armstrong v. Meade. The photographs attached to the affidavit of Randy Woodward show that the spot at issue was clearly visible to the naked eye in photographs, and there's nothing in the record that suggests that the visibility was anything but clear. Ms. Wood testified that she was able to clearly see in front of her. With that, I'd rest. Thank you, Your Honor.
Thank you.
Your Honors, Appellee relies on Daly to again try to get the expert requirement in for the defect. This case is distinguishable from Daly in many ways. In Daly, the plaintiff was walking across the lot and fell on some ice that was only in one area of the parking lot. They could not figure out why it was only there, so they just assumed that there must have been a defect in the parking lot that was man-made, so it had to be a man-made defect that was made by the owner of the premises. So they just supposed that it was made by the owner, and that's why they fell. The court said, you can't just suppose, there must be some sort of expert testimony to back up your supposition. That is not the case here. We're not just supposing, we're not making up how this ice got here. We are saying specifically how it came to be. To say that this naturally came, how they are saying this is natural accumulation. This pump was covered supposedly to protect the metal pump from weather. If we believe that, how did the ice and snow then come to be in front of pump 11? If it got there naturally. That is what defense is not explaining. Natural accumulation means it fell from the sky and landed in front of pump 11, or it blew there naturally. How did that happen? When there was no ice, no snow from their photographs, and those are photographs that they did in fact submit. There is no ice, no snow, no water, no accumulation of anything anywhere else on this entire lot except in front of pump 11. So how in any way, shape, form, or fashion is that natural? They have not produced one iota of proof of evidence. When they filed this motion for summary judgment, the burden of proof, the burden of persuasion, the burden of production switched to them to provide evidence. They can't just say, maybe it blew in, maybe she had something on her shoe, maybe. They cannot do that. We have provided evidence that says this is how it got there. We have provided evidence to say they were on notice. We have provided evidence to say they were aware of ice. We have provided evidence to say this is unnatural and this is how it came to be. We have provided enough evidence to say that they do not meet the burden of proof to say that there is no genuine issue. There's no issues that are no genuine issue, no genuine disputes, that they are entitled to judgment as a matter of law. They have not met that burden. They can't just throw up issues and say, maybe this is an issue, and we're able to receive a motion for summary judgment just because we throw out arguments. They have provided no proof of anything on her shoe. Open and obvious was not even discussed in the motion for summary judgment, but in her deposition, she did say, if I had looked down, I would not have seen it because my car was covering it. Of course she saw it when she was sitting in it, but it was not there to be seen had she have looked down, and that, in fact, is the standard. It was not there to be seen had she have looked down. The only way she could have seen it is if she had stopped, looked around the corner, and that is not the standard anywhere. No court has said that that is the standard. So in this particular case, they cannot just create a dispute. They have to show there is no genuine dispute, and the burden of proof and production lies on the appellee, and they have not put into evidence in the record that there is no genuine issue of material fact, and this court should overturn the lower court's decision and fine for the appellant. Thank you, Your Honors.
Thank you. Thank you. Thank you for your arguments this morning. We'll issue a timely written decision.
Thank you, Your Honor.
All right, the next case is C-240273, State of Ohio versus Curry. Good morning. Would you like to reserve time for rebuttal?
Yes, I'd like to reserve 3 minutes, please.
You may begin when you're ready.
Thank you. With respect to the first issue, the denial of the motion to suppress, I think this case, because of the language on that consent form, makes it extremely different from this court's decision in State v. Campbell. In State v. Campbell, the defendant seems to have given a blanket consent search to all random searches. So he can't have a Fourth Amendment violation to a search he's consented to. I think the form must have changed since Campbell, and Curry's consent form is not a blanket consent. It's a consent specific to the language in RC 2951.02, which is limited. In that statute, it only gives law enforcement the ability to search when they have reasonable grounds. So I would argue, and I think I did in the briefing, that Curry's consent is not a blanket consent. He's consenting to reasonable searches. He's not consenting to unreasonable searches.
So that's less than a probable cause kind of standard.
It is.
Right.
I think it is.
So are we looking more at like a Terry standard?
I think it's comparable to a Terry standard. That said, I think the case law that I cited to still states that when the information is based on an anonymous tip alone, and there's no verification of any of the alleged illegal aspects of the tip, then that tip can't be enough. It's not enough for probable cause, but I would argue it's not enough for reasonable grounds either.
The case law that you were citing seemed to deal with anonymous tips that were called in, as opposed to these tips that, at least one in particular, was a photograph of Mr. Curry. Is there some difference between pictorial evidence that might be in some way kind of self-authenticating or self-corroborating, and oral reports that need some kind of extra verification to show that they're true?
I think there would be 10 to 15 years ago. I think now, with how easy it is to edit photographs, how easy we can see photographs of people who aren't, I think I saw one yesterday on Instagram that was like, what if these celebrity couples didn't break up, and it was their faces on bodies with kids, and they look real. Like, if I didn't know that it was fake, I don't know that I would have caught that it wasn't true. So I think in this day and age, with how easy it seems to be to edit photographs, I don't think a photograph is necessarily any more useful than a simple phone call.
So it's no longer reasonable to rely upon photographic evidence without some independent corroboration? Is that your position?
Yes. And here, I think the judge sought to fix that by noting the hair color, right? Because he had orange hair color, and his officer testified that that was a recent hair color that she had seen. Therefore, this photo seems to be real and seems to be recent.
But you're saying that the probation officer needed to corroborate the authenticity of this photo somehow, right? That, I mean, hair color, whatever. How would she have done that? Like, what would be a way to do that if you're saying that photos can be altered and heads can be put on bodies? How could she have done that?
I think the same way that you can handle just a phone call, right? There has to be some follow-up on the alleged illegality. So is there somebody he's with? Are they going to say that he had a gun? If you call the place where he lives, are they going to say, yeah, he's had a weapon? Do you go out and see that if he has a weapon? I think if they had followed him and seen any kind of drug trafficking or anything that looked like it, then I think that would have been enough. And here, not doing anything.
This case is basically, you're saying when somebody's on probation and a probation officer gets a photograph like this, they have to automatically assume that it might not be authentic. Like, they can't, you're asking us to write precedent now that you cannot act on a photograph.
I think without something else in this day and age, I think there's a real risk if we can rely on photographs for something like this. Like, again, if it had been a consent search to everything under the sun, then the photograph really wouldn't matter. But here, because we're looking for reasonable grounds, I think the case law suggests that this is anonymous. And yeah, I agree that because it's a photograph, we want to have this discussion about whether it's different than a simple phone call. But again, I think because they're so easy to edit, like you can stick a gun holster in the picture. So it's, I think, more difficult. I think one of the other things in the record that caught my attention is I believe she never went to do a home visit. So does she then, because she has a right to do a home visit, go do a home visit and see what that looks like? Maybe that's a way to start looking into this photograph. I think maybe had she followed up with the person, right? Like, we can all track information. Does she go get her phone records, see what the phone number's coming from, follow up that way?
But in this case, didn't they do a home visit, essentially? They just did it in the middle of the encounter rather than the start of the encounter?
Right, and I think there's argument from the defense, if I recall correctly, that's not where he was, so I don't know that that issue was resolved, but I would say that this wasn't done for the purpose of a normal home consent. It was done because they found the bulge. And they shouldn't have been able to find the bulge because they shouldn't have been able to stop, pull him out, and essentially do a pat down the way that they did.
And so there was some dispute as to whether that was actually his residence?
Yes.
If we were to make a new rule, like Judge Krause said, would that be really tying the hands of law enforcement? I mean, if we're not allowed to rely on a photograph without a whole bunch more investigation, like you said, to check the phone records, well, it's very easy to hide where a call is coming from, or to, get a Google Voice phone number and call, send a text from somewhere that's not your home. I mean, not being able to rely on a photograph that, in this case, it looked authentic. It didn't look like a fake. What would be the result of that?
I think that they're just going to have to do a little bit more legwork to verify some of this. And I mean, the Ohio changed that form. So I think that reflects potentially a decision to weigh more in favor of defendants' Fourth Amendment rights, even though they're on community control.
But it simply has to be reasonable, right?
Right.
And your argument is that it is no longer in this day and age reasonable to believe that any photograph is real. So
yes.
You just automatically have to assume this might be a fake.
Yes.
Okay.
That's what I would argue. And I agree that it makes life more difficult for the law enforcement officer supervising somebody. But again, I think this is a legislative decision or a policy decision to put the defendant's Fourth Amendment rights ahead of whether or not law enforcement's job is more or less difficult.
I truly don't know the answer to this. It's above my pay grade in terms of technology. But is there software or some other technological tool that would enable law enforcement to detect whether photographs have been altered?
I don't know that I can answer that definitively, but based on my prior experience as defense counsel, I think so. I think if you can get it depends. Now that I'm thinking about it, I know when law enforcement gets a copy of an actual phone, so if you somehow manage to get the sender's phone, you can see if it's been edited based on the metadata. Now, whether an officer who's receiving that image can get that same content from it, that I don't know.
So it may be more difficult when, as in this case, an anonymous person sends in a photograph to a police officer who then sends it to a probation officer, and in the sending, it loses its metadata.
I don't know, it may or may not. I'm not sure how much of that actually gets transmitted versus kept on the original device that's taking the picture.
In this case, the photographs were from an Instagram page, correct?
I believe so, but I'm not sure.
Okay, so would an officer be able to rely upon photos that the person himself posted on Instagram?
That, I think, would be significantly more compelling for law enforcement. So if they would have found the, I guess I forget the word, the tagline, the title of the Instagram page, looked at it, saw multiple photos of him, and were able to be like, this looks like his page and he's posted it, then yes, I think that that would be a strong indicator that that photo is reliable. And I would argue now you're beyond the anonymous tip, because now you've looked at his Instagram page, thought through and verified reasonably that it's his, so now we're going beyond the anonymous tip to an actual social media page by the defendant.
So wait, so help me with the record in this case. How do we know that the photographs these were texted to this officer? Or how did they get the photo?
I believe that they were texted.
And how do we know it's from Instagram?
I want to say that there was something in the record where maybe it was specific to the text about the alleged drug trafficking, where there wasn't a phone number that the officer could verify as belonging to Mr. Curry. Instead, there was like a name. And I think there was some testimony that that name was like his and was an Instagram title. But I don't recall that specific part of the transcript.
And we don't know if the officer went to the Instagram page to verify, or do we?
I don't think they did. I want to say defense counsel asked questions along those lines, trying to see if the officer verified anything, and I'm pretty sure the record didn't say. I'm unsure about whether it came from Instagram. I am pretty sure defense counsel was asking questions trying to get to whether there was a phone number that could be verified, what the name was, how this in any way could be tied to a specific person.
Okay.
And if there are no further questions, I will sit down.
Thank you.
Morning, Your Honors.
Good morning.
Not really sure where I want to go with this. We've kind of gone down a rabbit hole here. I guess I'll start off by talking about this kind of notion that this was an anonymous tip. And the state does understand that those are generally disfavored. But the cases to which defendant cites, they kind of concern more generalized allegations, things like, well, a guy with red hair and a flannel shirt is holding a gun. Here we've got pictorial evidence, and I think Judge Kinsley might have touched on this, that it, in some respects, is self-authenticating, right? We've got a picture that by all appearances comes from Instagram or some other social media site. It shows defendant with this sort of distinctive hairstyle and coloring, holding what by all appearances is a gun. I think under the current state of the law, notwithstanding any advancements in technology, that by all appearances...
Well, and it has his name on it,
Right,
too,
well,
right?
sort of the weird phonetic spelling, K-W-O-N, which was, stylized a little differently, but by all appearances, this appears to be the defendant, this appears to be a gun, and the thing that we have to keep in mind here is whether we're analyzing this under the constitutional law, such as United States versus Knight or State versus Jones, or under Revised Code 295102, Mr. Curry, as a probationer, had a reduced expectation of privacy. And to answer your question, Judge Krause, I think the correct standard here is basically something tantamount to reasonable suspicion, which requires really only more than, an incoherent, inarticulable suspicion or hunch. And I think given what we have here, there was certainly enough to create reasonable suspicion. Maybe the cooking crack text didn't rise to that, but this picture that shows who by all appearances is the defendant and what is by all appearances a gun, that creates reasonable suspicion to do a home visit, to search his bedroom, and to do a search of Mr. Curry's person. I think it's especially telling, since we talked about Terry here as well, that because the allegation specifically concerned defendant holding a gun, that there was reasonable suspicion to suspect that when they encountered him, he might be armed and dangerous. I think everything kind of takes off from there. You find this bulge, he's evasive, they do the home visit, they find a gun in the bedroom. That's probable cause to arrest at that point, and the rest is sort of history.
Mr. Hill, how would you respond to your opposing counselor's suggestion that courts cannot take a photograph by itself as true anymore?
You know, at some point that may become true. I don't know what the current state of generative AI or photo editing is, but to the extent that she's suggesting that this could have been a fake, it was an awfully good fake, right? I mean, it had what looked like the social media, you know, they've got the ribbons and the pictures and sort of the way it's laid out, and, you know, it's a pretty good edit. Plus, I think a significant fact in this case is Officer Winter testified to this, that Mr. Curry had only recently changed his hairstyle. So you'd have to have a recent picture, you'd have to line up the head, you'd have to do all these things, and, you know, it may be the case that at some point that becomes true, and as I think Judge Kinsley pointed out, things might get very weird at that point, but as currently constituted, the law sort of says otherwise, and to make that categorical rule would be unworkable for courts, it would be unworkable for law enforcement. I just don't think that's something that this court should engage in based on the set of facts in this case.
Do you know, are there technological tools available to law enforcement to detect whether images have been altered?
You know, since I'm technically part of law enforcement, I should probably know that, but I don't. I'm a little bit of a Luddite, so I don't really have a good answer to that question.
I'll put myself in that category too.
Right.
So, right there with you. Okay.
Right.
So I want to clarify something that you said earlier.
Yeah.
You said that the text that said cooking crack and then the picture of what might have been drugs, you said that alone wouldn't have been enough.
I think it's a questionable call, right? Because there's no, you know, it kind of gets into that category of the guy with the red hair and the flannel shirt. You know, there was no indication who that text message came from. There was no, from what I could tell, independent corroboration that actually came from Mr. Curry or that depicted Mr. Curry. But a picture, as they say, is worth 1,000 words. And I think the Instagram picture certainly, you know, notwithstanding anything to do with the cooking crack photo, the Instagram post pretty clearly depicting what, by all appearances, was Mr. Curry with what, by all appearances, was a gun on his hip. That certainly created reasonable suspicion for the officers in this case to do what they did.
And I read the transcript, but I do not remember the answer to this. The Officer Winters did not testify that she looked at Instagram too.
Put me in the same boat as you, Your Honor. I don't remember if she did or didn't. And it may be the case that she may have attempted to do that, but as we all know, social media, you can put privacy settings on it such that even if she'd attempted to do that, she may not have been able to.
Okay, thank you.
Does the court have any more questions? Okay, well, I think I'm good then. Thank you.
Thank you very much.
Briefly regarding the Instagram account, it looks like in the state's brief, they said it what appeared to be defendant's Instagram account because the pseudonym was KWON and Curry spelled the same. And there's no indication, I've just flipped through our briefs quickly, that there was any attempt to verify if this was his or not. I mean, we can't prove that nobody exists named K1 with a KWON. And I don't recall there being any attempt to verify by pulling this up to see if it was public, to see if there were more pictures of him. And that would have taken a couple minutes. And then if it was private, you run into problems, but maybe it wasn't. And if the court has no further questions, I'm good. Thank you.
Thank you for your arguments this morning. We'll issue a timely written decision. And the final case is C-24-0266, State of Ohio versus Harris. Mr. Hill, thank you for doing double duty this morning.
Seems to happen rather often, Your Honor. I don't know. Talk to Julie about that.
Mr. Hoffman?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal, please.
All right.
I wanted to focus on the third assignment of error, and I wanted to discuss the standard of review a bit. This pertains to the contact between the judge and the jury. The claim is that it was outside without the parties being present. And the harmless error should apply and not plain error. I think that it's not appropriate to apply plain error, even though there was no objection in the record, because typically when you have forfeiture and plain error, the question is whether the claim or problem was brought to the attention of the trial court.
How could you bring something to the attention of the court if you weren't present?
Correct. Yeah, the issue is reversed. It's whether the parties knew about it.
Is the record clear that the defendant was not there?
It does not. It doesn't. There's no affirmative statement by the court reporter that the parties were not present. But I think that you wouldn't see that. I don't think a court reporter would put that on there. I think this is the kind of event where it occurs, and then maybe after the fact, there might be some.
The defense counsel would then, if the defense counsel found out that the judge did this without the counsel being present, wouldn't defense counsel then put that on the record later? That, Judge, you did this outside the presence of the lawyers?
Yes, they probably would have.
Okay, and that wasn't done here?
No, it was not.
But how would they know? I mean, without somebody transcribing that or telling them or something, how would they know that that occurred?
They would have to be, the court would have had to tell them after the recess, after they came back, that it happened. There's a summary of what happened that occurs between the two notations of recess, but there's no indication that that summary was made to the attorneys. I mean, it might have been made in the record.
Is this a claim that could be cognizable later in post-conviction? I mean, could an outside the record reconstruction occur? Could people put in affidavits of whether they were there or not there?
I think that the only matter outside the record would be the presence, whether they were present or not. And I think there's enough in the record to indicate that they were not there.
And what is in the record to indicate they're not there?
Well, there's no exchange, for one thing, between the court and the parties with regard to the question and the answer. Usually there's some back and forth about what happened. Usually it's in writing, and usually the response is maybe not agreed upon, but at least there's a statement to the parties that this is what the answer is going to be, and they have a chance to, respond. None of that happened here.
So this is something you're saying, maybe the reason why there was nothing later put on the record is because defense counsel never knew this took place.
They might still not know.
Until you got the transcript and saw it?
Right.
Okay.
Possibly, yeah. There's no indication they were present during the summarization. And
Can you explain what the prejudice would be?
it's difficult. But the luxury of this harmless error rule is that it's not my job to do that. It's more the state's job to prove that there was no contribution to the conviction beyond a reasonable doubt. That's why it's a big deal, the standard of review. It's night and day between plain error and harmless error. In the court, the case I found about the IDERA case makes me think that the way courts deal with this is, instead of looking at prejudice, they look at substantive versus non-substantive. And from that case, it looks like if the question and answer deals with if it isn't a housekeeping matter, like, when do we show up you know, what's the court security like, things like that. If it's a non-substantive matter, then it's not going to be prejudicial. But if it deals with the facts of the case, and in this case it was an exhibit, and in IDARA it was an exhibit also, that's substantive, and it deals with the matters of the case itself. And they just said that that's prejudicial, especially where
Well,
it
in this
dealt with
case, it didn't deal with the substance of any exhibit. Instead, it was that the exhibit didn't exist.
That
Does
was
that make
my
a
first
difference?
impression, until I thought about the dichotomy between substantive and non-substantive. That's a pretty broad category. It's non-substantive, it's easy to think of examples like, you know, when do we show up, you know, can we have lunch? The substantive would be everything else. It would be things that deal with the case itself. And if you take it to an extreme, even though you're just referring to an exhibit, I mean, it could be very important. In a murder case, you know, an exhibit with DNA on it, you know, it could be something non-contentious, you know. People may all agree that the defendant's DNA was on an exhibit. But if that's what the court tells the jury, I mean, that's a big deal.
This
go ahead.
CAD report that they were asking for, I mean, didn't it relate to the basis for the police call, and that was more connected to the criminal trespass charge that he was acquitted of?
No, actually, that's not the impression I got, Your Honor.
All right, walk me through that.
The use of that CAD report by the defense was to prove that there was only a 1-minute time period between the call for backup, and that was before the Officer Brooks even entered the restaurant, and the defendant being secured in the back of a police car. And a lot took place during that 1-minute period.
All right, so is the timeline for the OOB?
Yes, and
That's
the
what you think
resisting, and the resisting.
Okay, that's what you think the purpose of the CAD report was?
Yes, yeah, and that was spelled out, and there was a post there after the at close of all evidence. There was a big discussion about that, and so it was that's where the defense spelled out the importance of it.
But that was discussed during the trial on the record, but wasn't the call made by some off-duty officer, the initial phone?
Yes, that's correct. And there was some.
So no CAD report gets generated at that point.
That's right, and that's what kind of what the confusion was about.
Okay.
But I think that it was Officer Brooks clarified that the CAD report was generated by his call for backup and not the initial call that he received as he was driving past the restaurant.
Okay.
So I'd asked that this court would find that the jury contact was ex parte, and that it did address a substantive matter, and that therefore it should be considered prejudicial and reversible error. Thank you.
Thank you.
Morning again. So a couple things here. I think first of all, the starting point for this is that the record is completely ambiguous as to whether or not this communication between the court and the jury was ex parte.
Can we infer, as your opponent is inviting us to do, that no one was there because no one spoke?
I think that's potentially one assumption. Racking my brain as I was preparing to argue this assignment of error last night, I think I could think of maybe 3 things off the top of my head that happened here. The first is that Mr. Hoffman is correct that this was an ex parte communication that the trial court later memorialized. Now, why she would opt to basically out herself for committing an ex parte communication, I don't know. The second thing that happened is that the only person that was not present for this communication was, in fact, a court reporter. The attorneys actually were present in the room. She advised them as such and then later memorialized that for the record on appeal. The third presumption is that it was ex parte in the sense that the parties were not there, but that there was some communication with counsel for the party and saying, hey, the jury's got a question. Do you guys want to come over here? No, it's just about whether or not this thing's in evidence. Please advise that this exhibit is not in evidence. So, again, I think the only thing that we can say for certain is that the court reporter was the non-present party when this communication took place. Anything beyond that would just be making assumptions based on facts that are not in evidence here. I think the bigger issue, though, is that I agree with Mr. Hoffman that the standard of review here is harmless error, has to demonstrate that there was not prejudice. And I don't think there's anything in the record to suggest that there was prejudice in this case. I mean, basically, it was a succinct and accurate discussion of what was and was not in evidence here, right? This exhibit was for demonstrative purposes only. I know Mr. Hoffman has gotten into what the significance of that exhibit was, which begs the question why the defense counsel didn't move to just simply put it in evidence. But the fact of the matter is the exhibit was not in evidence. So when the trial court advised the jury that this exhibit was not in evidence, that was just, it was accurate. And I don't think it pertained to a substantive matter. You know, whether or not a communication is substantive, this is State versus DiPietro. It's a 10th district case that I cited. It's substantive when the communication addresses legal issues, any fact in controversy, any law applicable to the case or some similar matter. And here we would submit that this does not rise to that level. Basically, it was just almost not per se a procedural question, but pretty much a housekeeping matter. Hey, can we have this exhibit? No, it's not in evidence. So if the court has any questions, I'd be happy to field them, but beyond that, I've got nothing. Thank you.
Thank you.
Take care.
I don't have anything to add, Your Honor.
Thank you very much. We'll take the matter under submission and issue a timely written decision. Thank you for your arguments. Have a great day. That concludes our docket for this morning.